Hey everyone, and welcome to This Explainer. I am absolutely thrilled you're joining us today because we are digging into a truly fascinating constitutional law case out of South Africa. It's the case of Simon Proffit. We're going to unpack a legal situation that, at first glance, completely defies common sense. Seriously, it's a wild story about a suburban home, a frantic police raid, and a legal fiction so powerful it literally went all the way to the highest court in the land.
So let's kick things off with a question that sits right at the heart of today's topic. Can the government just seize your house, like permanently take your property away, for a crime that a court of law found you not guilty of? Your immediate instinct is probably to say, no way, that completely goes against every rule of justice I've ever heard of. But, the law is full of surprises.
Because the contrast here is just staggering. On one hand, we've got our guy, Simon Proffit, standing in criminal court where he is fully, officially acquitted. The state completely failed to secure a conviction against him. But then, on the exact same set of facts in a civil court, he loses his home permanently to the state. How in the world do these two totally contradictory realities coexist? Well, to understand this massive cognitive dissonance, we've got to go back to where it all started.
All right, moving into Section 1, inside the suburban drug lab. We're going to step away from the legal theory for a second to look at what actually triggered this massive constitutional showdown at 54 Balfour Street.
When we look at the timeline, it's like watching two totally independent tracks running side by side. In January 2001, police raided Proffit's home in Woodstock, Cape Town. Very quickly, the state kicked off civil proceedings, securing a preservation order on the house by June, and eventually a full forfeiture order by May 2003. But get this, notice that last date. It wasn't until April 2005, years after his house was already forfeited, that Proffit was actually acquitted in his criminal trial. It's two different courts, moving at different speeds, spitting out totally different outcomes.
So what actually went down in that January 2001 raid? Well, the police had gotten a tip about imported chemicals. When they raided the house, knocking and then eventually forcing the door open, it was just chaos. They literally saw Proffit running away with a cardboard box. They heard breaking glass. Someone was frantically pouring liquid down the kitchen sink drain. And they found all the classic hallmarks of an illicit drug lab. We're talking bottles of methylamine, phenylacetic acid, chilled chemicals stored right there in the household freezer, plus vacuum sealers and straws that are routinely used for packaging drugs.
Now, you might be thinking, okay, maybe it was just a tiny amateur setup. Proffit actually claimed later he was just dabbling in an alchemy hobby. But a forensic analyst took a look and determined that the chemicals found could synthesize up to 600 grams of methamphetamine, which is locally known in South Africa as tick. The street value of that yield? An estimated 250,000 rand. This was a highly lucrative, highly dangerous operation nestled right inside a quiet residential neighborhood.
Which brings us to Section 2, Civil Forfeiture and the Law. This is the part where we look at South Africa's Prevention of Organized Crime Act, commonly referred to as POCA. This is the exact legal loophole that allowed the state to go after Proffit's house, totally regardless of his personal criminal guilt. Get ready for a seriously mind-bending legal concept under Chapter 6 of POCA. Civil forfeiture doesn't put the person on trial, it puts the property itself on trial. I know, it sounds crazy, but the law essentially treats the house as the actual wrongdoer. Because the property is technically the defendant here, that whole traditional standard of innocent until proven guilty for a human being, it's completely bypassed. It's designed as a remedial measure to combat organized crime, not as a punishment for the individual owner.
Okay, let's jump to Section 3, instrumentality of an offense. Because the state can't just snatch up any random piece of property, right? They have to prove a very specific, tangible connection between the house and the crime.
Basically, to clear this legal hurdle, the state had to show that Proffit's house wasn't just some passive backdrop where a crime coincidentally happened. The property had to be fundamentally linked to the illegal activity. It had to be functional to the commission of the crime in a very real, very substantial sense. And honestly, in Proffit's case, the evidence for that was overwhelming. This wasn't just a couple of beakers left out on a kitchen table. The house was deliberately equipped and adapted for manufacturing drugs. A small room was completely fitted out as a mini laboratory, complete with an extractor fan and specialized lab gear. Almost the entire house, we're talking all 5 rooms and the garage, were used to store chemicals, house equipment, and facilitate the whole operation. The property itself was practically weaponized to break the law.
So that brings us to Section 4, the proportionality test. Look, just because the property is used in a crime doesn't mean the state gets an automatic green light to seize it. This is exactly where the case elevated all the way up to the Constitutional Court. The judges had to perform this incredibly delicate balancing act, weighing the urgent need for public safety against the fundamental, everyday property rights of a citizen.
Simon Prophet pushed back hard. He argued that losing his home flat-out violated Section 25(1) of the South African Constitution, which protects citizens against the arbitrary deprivation of property. His argument was essentially, hey, I wasn't convicted, you only found a small amount of precursor chemicals, and this is my home. Taking it from me is just an arbitrary, disproportionate overreach. To figure out if the forfeiture was constitutional, the court relied on a step-by-step proportionality test. First, they looked at the purpose of taking the property, which is obviously stopping organized crime and dangerous drug manufacturing. Second, they looked at the relationship between the property and the crime, which, as we just saw, was deeply intertwined. And finally, they looked at the extent of the deprivation. Yes, Prophet was losing his home, which is huge, but he also owned other property and collected rental income, so this specific seizure wasn't going to leave him completely out on the street. And this is a brilliant example of the macro versus micro view the court had to grapple with. On the micro level, sure, it's one man losing his house in Woodstock. But on the macro level, the court absolutely had to recognize the devastating social damage that residential drug labs cause in South Africa. Specifically, they looked at the absolute scourge of tick in the Western Cape. These mini-labs fuel violence, tear families apart, and cause massive social instability. The court had to weigh Prophet's private loss against that overwhelming public harm. All right, let's wrap this up with Section 5, the Constitutional Court's verdict. This all culminated in the final decision delivered by Justice Nkabinde. The court had to decide, once and for all, was this forfeiture constitutional, even without that criminal conviction?
Ultimately, the court ruled against Simon Prophet. And what's really striking is that Justice Nkabinde didn't just stick to dry legal jargon. She anchored the strict legal reasoning in profound empathy and social responsibility. She stated, and I quote, "There is an alarming rise in illicit production of undesirable dependence-producing substances. They pose a serious threat to the health, welfare, and safety of human beings." The court concluded that forfeiting a house intimately adapted for this kind of societal destruction was entirely proportional. It wasn't arbitrary at all.
So we come back to the ultimate resolution of our paradox. Why was Prophet acquitted in the first place? Well, it turns out his criminal acquittal was due solely to a technicality. The magistrate deemed the search warrant used in the initial raid invalid. In a criminal court, that meant all the evidence had to be thrown out. But under the POCA legislation, a criminal outcome does not magically erase the civil reality that the property was heavily adapted for and used as an instrument of a crime. The property itself was guilty, even if the owner went free.
It's a reality that totally challenges our basic assumptions about guilt, innocence, and consequence, right? The Simon Prophet case shows us that justice isn't always just about the person. Sometimes it's about the tools they use. So I want to leave you with this final thought. If your property is weaponized to commit a crime, should you pay the price of losing it, even if you personally walk free? It's a tough question, but it's one the courts have answered with a resounding yes. Thanks so much for joining this explainer, and keep questioning the systems around you.